Welcome to our weekly Challa Law webinar. Let's give it a few minutes and get people to get situated and log in, and then we will get started. I hope you all had a good and safe weekend. I hope you didn't have too much snow and you're enjoying the week. For any of you who have questions, remember we're going to have our Q&A at the end. And if you're going to place your questions, place it in the Q&A. Please don't place it on the chat. So let's get started, shall we? There we go. If you haven't connected with us, please connect with us on, we've got multiple platforms. Either you can connect with us on Facebook, Twitter, Instagram. We use different mechanisms for different types of outreach. So, however you're able to connect to us, I would just say connect to us. And then we also have a YouTube channel. So if you haven't watched our YouTube channel, or you missed one of our webinars, you are able to watch it on our YouTube channel. And we have a lot of things on the YouTube channel that are applicable for any type of immigration process, not just limited to the latest changes, but even things that will impact you for different situations. So please check out our YouTube channel, subscribe, comment. I'd love to hear from you, and make sure you share it with your friends. So overview, we're going to go over the registration, the H-1B registration rule. And from that, I know I'm getting this glare. I'm trying to get rid of the glare. And I think there we go, this does it. So the H-1B registration rule, the requirements, is the old H-1B information going to be, the Trump era changes, will that be implemented, is going to be, I know, one of the issues. And the filing tips and what we suggest for a successful H-1B filing. So part of the registration rule, if you remember, was implemented 2 years ago. And actually, this was a good change that we had seen. Previously, you would have had to have filed your H-1B petition. You'd have to pay, legal fees and so forth. And then if the petition wasn't selected, you would be out legal fees. You'd get back your filing fees, but there was a lot of anxiety in that process. So then they changed it. So two of the things that they changed, they allowed for pre-registration, and they changed the way H-1Bs are selected. So they changed that process. Whoops, I'm trying to push myself to the corner. So that in an attempt to see if more people with an H-1B master's degree could be selected, they changed the process. And they suspended the registration requirement till last year, and it was implemented. It did really well, and it did achieve its objective, which is trying to get more people who are master's degree to get through the selection process. So H-1B registration requirements. Petitioners must pay a $10 registration fee, and for each application submitted, and the registration is same as it was last year. One registration per beneficiary per company. If you've got two beneficiaries that are registered on behalf of one company, you're most likely going to get that, not be selected. So the beneficiary can be registered by multiple companies. There's no prohibition in that, but you can only register one beneficiary per company. So that's why the basic information, mandates having the beneficiary information as well as the company information, so they can assess that. Secondly, the filing process. So then the petitioners who are just selected will file a complete H-1B petition during the registration period. So selections will be made by March 31st, which I still hate. I wish they would do it earlier. So for most people, it's probably a good idea to go ahead and get your petition complete as much as possible before the selection period. I mean, that's what my advice would be. That way, if there's any issues that your attorney spots with relation to some problems that they see in the petition, or perhaps problems they see, with an RFE that may be issued, you can address that before you file. And so that's so much better than filing and then finding out there's a problem. So the account creation, it opens up, on between March 9th and the 25th. And the notifications come out on the 31st. And the earliest date that you can file is April 1st. April Fool's Day, what a interesting and very telling kind of deadline. And the employment starts October 1st. There's all sorts of things like cap gap that are still in place that you can remember. And one thing I always like to tell people is if you're changing status, please remember if you file for a change of status and you leave the United States while the petition is pending, then you have abandoned your change of status in the US. So that's something that's very important. So processing times, the candidate's spot in line, status issues, and the likelihood of an RFE are a lot of the things that you should take note of while your petition is being prepared. We like to proactively look at it. So we've got 3 different options that we give clients. One is just the registration, and they pay for the registration fee and our administrative fee, and they don't have to pay for the H-1B petition unless it's selected. But that means we won't touch it until the day of selection. So you may be running into some time issues. We have another option where we do the preliminary analysis and we do the registration. So we can issue spot any problems up front, but we don't prepare the actual petition. Finally, we do the full preparation, where we prepare the H-1B petition prior to filing. So with the option 1, we just need basic demographic information and linking the employer account. As I said, with option 2, this is one. Option 2, we evaluate the job title, the job descriptions, the duties, including the beneficiary's educational requirements to see if there's any problems, because we want to avoid an RFE. We don't want the RFE. So we try to issue spot that ahead so that, at the time that you're getting ready to file, we just have to prepare the petition. Option 3, we recommend, because it's the option of least resistance, where the candidates have never had an H-1B before and the employer's not familiar with the process, so we get everything prepared ahead of time. And that way, if they're selected, we can file. So it's the full preparation. Because remember, we also have to file the LCA. And the LCA can take 1 week if it's a company that's filed H-1Bs before, or it can take up to 10 days for a new company. The other consideration is a lot of times the DOL website shuts down during H-1B time because of the vast number of petitions that are filed. So this would in some way alleviate some of that. And if it's a unique role that is not typically deemed a specialty occupation, like for example, user interface. The DOL's job titles are dated. They were from back in the, I think, late 1990s, early 2000s. So that means there's only a very limited number of IT occupations on there. They didn't think of user interface or smart applications or things like that. So those kinds of roles take a little more preparation, detailed job descriptions and so forth. And sometimes I even submit articles that will explain to the USCIS, who may not be so tech savvy, as to what exactly that particular position is. So this is what the registration account looks like. So the attorneys will prepare and create an account, and they'll register the beneficiaries for review and the electronic signature. Once you've received a password from your attorney or representatives, you enter the representative's passcode, and the petitioners enter a unique passcode from the attorney and review the summary and electronically sign. So it's both the employer and the employee, so that, years ago, I would say about 20 years ago, you had certain attorneys that were filing perm applications without the knowledge of the companies, just for people, and selling them for a ridiculous amount of money. And so these kinds of safety measures were put in place because of that. Now, notwithstanding the more friendly administration, there are still some things that you have to look at in terms of H-1Bs, RFEs, with the typical, issues relating to specialty occupations and things like that, foreign degrees and the relationship, third-party placement, and the public charge rule until it gets denied. And you can see that because we are so proactive in our approach, our denial rates are substantially lower. And I think one of the denials that we received on an H-1B had to do with, they were trying to get a tax exempt, which we advised against, but they did anyway. So, and then there was the other, we got it approved on the refile. So September 2018, they've really expanded the discretion that officers get in adjudicating applications. What does that mean? That means that petitions can be denied without even the issuance of an RFE. And this was meant to discourage frivolous or substantially incomplete filings, but it has had some negative effects even for valid filings as well. So applicants with foreign degrees, the H-1B is a petition for someone with the equivalent of a US bachelor's degree. So for those people who have maybe 3-year degrees, you have to get, if you're not in a US master's program, if you are in a US master's program, they will deem that you've already had your degree evaluated. But if you have not, they try to look for, you have to get an experiential letter, which means that for every 3 years of work experience, it's equivalent to 1 year of degree. Or you can have maybe a 3-year degree and you've had a couple of advanced degrees in your home country. And so they would see, the evaluator would look to see if the multiple advanced degrees plus the 3-year degree are equivalent to a bachelor's degree. One tip that I want to give you is if you are using the equivalent, work experience equivalent, the regulations state that you have to get, there's several ways and you can get the credentials evaluated, but the most common way is by using an evaluation from a university representative who A, has the authority to review work experience and give college credit, and for a university that does have the mechanism in which they can evaluate college credit for work experience. So a lot of times people will just get a standard credentials evaluator, and that does not meet the regulations. So that's something that I would have you look at. Specialty occupation. As I said, there are a very limited number of job titles within the DOL, and that is what the USCIS looks to assess whether it's a specialty occupation, the DOL resources. So you want to have a detailed job description, and you want your attorney to be proactive and make the argument that not only is the job highly specialized, so it can be deemed a you need a bachelor's degree for minimal entry, but you also need to show that there's a relationship between the degree and the work the individual will be doing. And you do that with details. So like I said, these are all the occupations that are listed under the DOL. And this was many years ago, so there's a lot of things that you don't see on here. And what happens is if it's not on this list, it goes to this dump list right here at the bottom that is called Computer Occupations for All. So the computer occupations for all, the problem is they don't list a specific degree. There's no level set, because it could be anything from software engineer to user interface to a wide variety of IT positions that are not readily outlined. So that's why they couldn't give a specific degree. Now, we've used that argument, a couple of other arguments, and we've been successful with it. But that is something that you need to know that is an issue. Software engineer is another. And the Adjudicator's Field Manual, which was adopted by the USCIS policy manual, actually clearly outlines that, hey, adjudicators, although you look at Department of Labor's Occupational Outlook Handbook, know that this IT landscape is growing and evolving. And so use it as a reference, but don't use it as the sole source. So that's something we've referenced to make sure that they understand that they can't be too restrictive in their review. So the IT Serve memo rescinded the two H-1B memos that were issued that basically said that the employer has to establish and provide information on all the contracts for the duration of the H-1B petition. The itineraries, you have to show employer-employee relationship. And you still have to show employer-employee relationship. But the standard in the regulations has always been that the work has to be anticipated, not speculative. So as long as you can show through history of the company or history of the particular contract, it is, you are able to show through the preponderance of the evidence, which is the standard that's supposed to be outlined, that there is sufficiency of work. The public charge rules. So it still has to go through additional scrutiny and making sure that you haven't received the prohibited types of benefits under that rule. Wage selection is delayed till December 2021, and I really think that it's probably going to be rescinded. So that's good news, that we don't have to worry that this selection will be dictated by the wage of the employee. H-4 EADs, the rule to remove H-4 EADs has been saved. Yay! The problem is, though, we're still waiting for the ridiculously long biometrics for some to get their EAD. So there's been lawsuits for the processing delays. And I know that a lot of people saw the rules for premium processing for certain EADs, but that has not been implemented. So you have to craft your immigration strategy. Remember, you are the solely responsible for your immigration. So even though your employer is the one that's filing this on your behalf, think about your job title. Make sure that the job duties are very detailed and specific. Make sure that you let your attorney know, even if they don't ask, how your education is related to the work that you'll be doing. Make sure that there is evidence of employee-employer relationship. So there are some things that you can do to control the outcome of your H-1B petition. So we're going to get started with Q&A in just a second. We have our moderator coming on, Shekhar Challa. If you haven't joined our forum, please do that. We have a Challa chat forum where we'll be updating the latest on the immigration changes, and I think my team will send out in chat the link to that. It's called the Challa Chats Forum, and it's Clarity Forum. So we hope to provide you clarity through this forum. So please, join us on the link, share it with your friends. I would really appreciate that. And then, of course, as we said, you can connect with us in many ways. And I love connecting with you guys. I love this time that we have every week where we can talk about some questions that you have and we can provide some guidance. And don't forget to look at some of our YouTube videos if you missed our webinar. And like I said, comment, subscribe, share it with your friends, and let's make sure that we are creating a greater conversation on immigration issues that impact all of you. As I said before, I am working to craft, I have alerted the administration to the challenges of the prohibition on visa issuance due to Trump's proclamation ban. I've listed details as to what they can do. I've also provided suggestions on what we can do for the F1s who are waiting for their biometrics and are waiting, for the Dropbox delays, and how they can apply regulations or rules that they've done previously as a stopgap so that these students can get work authorization. And so what happens is this platform, whether it's the webinars or whether it's the forums, allows me to understand the issues so I can be a voice for you, for the administration to get some positive changes for our communities. If you have a question that has not been answered, please email us at info@challalaw. That is info@challalaw.com. And let's get started with the Q&A.
All right. Good afternoon, everybody. Hello, Lakshmi. How are you?
How are you?
Good. Got a different background there.
Yes, I had some problems with the sun earlier, but it seems to have.
Yeah. Well, there won't be any sun for some time. Looks like we're going to getting some lot of snow. So, just prepare yourself and don't just run to the grocery store and, elbow people and all that. Just be calm and just get whatever you want. I've seen people get crazy on the streets also when they're driving. So be careful out there. Okay. So let's begin with today's Q&A. February 10th, attendee AA. If I use a EAD with EB3, will I be able to switch to EB2 in case final action date is current in EB2? And if yes, what is the procedure? Here I have I-140 with EB2 and EB3 with the same company. My PD is November 2010. Thank you.
Yeah, all you have to do is you don't have to do anything with your EAD. There is somehow there's a misperception that an EAD used for EB3 cannot be used for a subsequent EB2 filing. What happens is, remember, the employment authorization document is tied to your adjustment of status. Your adjustment of status is currently tied to your EB3. So all you have to do is interfile. That means you send a copy of your approval notice. There is no formal form to the USCIS and let them know that you have an approved EB2. And so because the EB2 then supports the 485, and the 485 is what supported your employment authorization. There's nothing else that needs to be done.
All right. Next one is from another AA. What is the last action rule? I extended my H-1B and have not traveled since then. My I-94 is expired. However, they did give me new I-94 in the approval notice. Do I need to get another I-94?
What do you mean? You said you,
Yeah, I'm not sure what he's asking.
okay, so you had an H-1B, you have applied for an extension. Okay,
and
so once the extension is approved, you'll be issued a new I-94 card.
He did get it.
So it's already been approved. So your extension has been approved. So if your extension has been approved, then that's it. That's your I-94 card. Last action rule only applies, let's say, for example, you had a valid H-1B visa. You applied for an extension. You then the extension is valid till January 2022. However, your visa is from your previous H-1B. So you changed employers and filed an extension. So, and that one was only valid till August 2021. So in May, if you travel outside the United States and you re-enter, and you present your, without showing them your approval notice for your previous amend and extend to January 22, and they give you an approval, an I-94 that's only valid till August of 2021, that is the I-94 that governs, because it's the last action, right? Your approval notice from your H-1B for 2022 occurred previously. You re-entered, did not show them, and this happens all the time, believe it or not, did not show them the approval notice of your amend and extend, so that they only approved it up till, your visa. And, typically, if you had shown them the I-94, even if your visa was going to also expire in August, they would have given you an I-94 all the way to January 22. So whatever is the last action, whether it's by CBP or whether it's by USCIS, is the action on your petition that governs.
Okay. Another question from another AA. With many changes that have happened regarding H-1Bs, do you see any challenges with the filing extension of existing H-1Bs in coming months related to any changes by executive action by previous administration?
No, because the Biden administration, whatever had not been implemented by the Trump administration is on hold. So if you remember, a lot of the immigration restrictions that they put in place were overturned by federal agencies. We've got a couple of YouTube videos that just talk about that. So because they were overturned by federal judges, that's what governs. That's what the USCIS has to adjudicate, is what the federal, when a federal judge makes a decision. And it was funny, in one of the RFEs, the USCIS said, well, I don't have to listen to a federal judge. And I told him, I'm afraid the Supreme Court and the Administration Procedures Act, which governs your agency, says you do. So you have to listen to the federal judge that says that that's unlawful. So all those restrictions that were put in place should no longer be an issue because of the two measures. One is the federal district judge decision, and two, because the Biden administration will not implement rules that were not that have not been rolled out.
All right. Just wanted to request to submit questions in the Q&A box and not in the chat. Mr. Akash Bhandari, I will read your question from the chat, but don't copy again and put it in the Q&A. But I'll get to your question within a couple of minutes, Akash. First, another AA, good afternoon. Just a quick question. If you have two H-1B visas approved, can you work for both employers at same time without one being converted to concurrent H-1?
No. I wouldn't do it that way because you can work because on each application, you're saying you're working full-time, 40 hours a week. It's hard to work 80 hours a week, right? So I think that they would run into some issues with that if you're trying to work for both. That's why they do concurrent. You can, the employer is supposed to revoke an H-1B if you're no longer working for them. So a lot of times, even though they're supposed to, because they have ongoing wage obligations, they may not. And if they don't, you can change from working from one employer to working for another employer. They have to re-I-9 you. But, if you want to work for two employers, I would do it through a concurrent filing.
All right. Akash, I saw you posted the question in Q&A, so I'll get to it as per the chronological timestamp. Let's get to the next question. You're okay there?
Yeah, she's eating my malipulu, my jasmine, so I'm trying to.
All right. Suketu Trivedi is asking, can STEM OPT student work without a receipt just based on filing?
No, but that's what I've asked. I've asked that, well, if you've had an OPT, I believe for those STEM you can, but I think a lot of people are not even getting a receipt from the Dropbox. I'd have to look at what I wrote down in my recommendations, and I will let you know. Can you email me at info@challalaw.com, and I will tell you what I had outlined for the Biden administration.
Okay, the next one is on the H-1B that, I-94, he says, he or she, I don't know, yes, it is approved. So I think we've already answered that. So go to Suresh Shastri. How long can I be outside USA before I enter using EAD AP? What documents should I have in possession for entering USA using EAD AP?
There is no, of course, there is an expiration on the AP, right? So you'd have to enter if you're using that as your mode of entry before the expiration. But I would have, if it's going to be more than a few months, I would make sure that you had a current confirmation of employment letter from your employer. And that should serve to let them know when you re-enter that there is a valid job offer.
Okay. Krishna Anapragada is asking, what happens to my H-1 status if I use my AP while returning to the US? Can I continue on H-1 without I-94?
Yes. The only time where your H-1 is no longer valid is if you use the EAD to work for an employer other than your H-1B employer.
Okay. So here's Akash Bhandari with this question. I had applied my H-4 and H-4 EAD August 2020. I got a fingerprint request for February 5th. I completed that. How long it will take to receive my H-4 and H-4 EAD? I have a travel plan for April 1st week. Is there any way we can expedite the process? Please advise.
They're working on that. There's a lawsuit in place. F1s are having the same problem. So I understand that they're going to try to review that and get that addressed. So hopefully it will be addressed by the time you have your travel, and know that that's something, like I said, I emailed someone last week. I emailed someone this morning. it is something we're trying to get resolved as quickly as possible.
All right, next question from an AA. Does your law firm help in filing I-130 for married son? And do you recommend in filing it considering the backlog times?
Yes, I would go ahead and do that. I think they're going to address the backlogs at some point. Congress even said, let's take care of, the COVID relief, and then the next thing we'll attack is immigration. So getting the filing in place is the best way you can get yourself ahead of the queue. And yes, we do assist people with the I-130 filings.
All right. Another AA. I heard from another attorney that we should not use EB3 EAD AP if we have opportunity to switch to EB2 if that final action date becomes current. And also, if we have kids closer to 21 years. Is that not true? Why that attorney is suggesting not to get married to EB3? Thanks.
That's weird. I have no idea. But you can email me and maybe we can set up a time to talk, but they're highly unrelated. So I don't know why the attorney would have suggested that.
All right. There is Sai Sagar Adimulam. He's got a long message and question. I'm on H-1B, which will expire on August 2nd, 2021. And my wife is on H-4, will August 22nd, 2021, I guess, expire too. We applied for H-4 EAD in 2018, which will expire on July 17th, 2021. She's pursuing her master's degree and used her H-4 EAD to get a graduate assistantship. Now, my situation is my company started processing for H-1B and H-4 extension, and they're not willing to apply premium processing. So I have to pay out of my pocket to get premium processing with my company. And I came to know that cost went up to $2,500. So I was thinking to get the normal processing to get started for H-1B, H-4, and H-4 EAD parallelly. I can try through Congress. Parallelly, I can try through Congress, Senate, USCIS to get biometrics done, which is taking about, again, 4 months these days by the time I get my H-1B approval and normal processing. Need your input based on my situation and on my thoughts for regular processing. I came to know if your biometrics are done before H-1B approval, I can get H-1B and H-4 approval at the same time. Is that true?
Yes.
That's the end of his message.
And he wants to go to school?
No, his wife is doing master's degree. He has a graduate assistantship.
Oh, okay.
His current company started processing his H-1B and H-4, not willing to do premium processing.
Yes. I mean, once your biometrics are done, you can make a request, and they should adjudicate the H-1B and H-4 at one time. So it may be a good idea is once that's done to go ahead and upgrade. Sometimes they don't do it. You have to just make sure that it's clear on your request and that they know that the biometrics were taken care of. I'd wait a couple of, they have to update the system. So I'd wait a couple of days if you're going to do premium because you've only got that 15 days.
Okay. Once again, ladies and gentlemen, please submit your questions in the Q&A box and not in the chat. I will get to the questions in the chat that have already been submitted, but and don't resubmit in the Q&A box. Thank you. Vignesh Reddy is asking, I'm on a CPT authorization and I have not used my OPT yet and will graduate in December 2021. And my employer will be filing for my H-1B. And assuming that my applications get picked up, and if there is a delay in getting the result or denial later in the process, can I still apply for OPT EAD? Will there be any issue?
You're on CPT and they're going to apply, I would imagine, in April When are you eligible for your OPT? Are you eligible in May?
Graduating in December 2021.
Yeah, but if it's selected and it's approved, you'll be on an H-1B in October 1st. So why would you then want to, you're no longer on an F-1 come October 1st. So you can't apply for your OPT.
Okay. Maunik Panchal is asking, I have applied for OPT EAD card in November, but I have not even received any receipt notice from USCIS. What should I do? Until what time I can stay in US? I completed my MBA in December 2020.
Both NAFSA and American Council on Education, and of course we are trying to push that, you get that through. I think for right now, I think you should be fine because the regulations stipulate you can only file a certain time prior to your graduation, which you must have done. And the regulations also stipulate that on that OPT, once you get the OPT, you can't be without work authorization for a certain statutory period. Well, you haven't received that yet. But stay tuned, we're looking on some guidance for that. And as soon as we get that, we'll make sure that it's sent out. I know that, it's on the top of my list. That's why I keep reminding people. There's a lot of things going on right now, with the impeachment trial, the COVID, mainly the COVID, and the transition of administration. So I think it'll be resolved fairly quickly, but like I said, stay tuned.
Okay, I've got a question now from the chat from Srinath. I applied my I-485 in October 2020. I got a rejection on February 2nd due to not answering question 10. It is a mistake by my attorney. My question is, if I refile with corrections, does USCIS accept my application?
Not if
Currently, my PD is not current.
No. That's why I told people that, I have seen where there was a certain period of time where the I-944, USCIS was enjoined for asking that. We've had a couple of filings during that time. So legally, we couldn't file the I-944. They later reversed it. And then they said, they rejected it saying, hey, you didn't file the I-944. Well, by law, they have to accept this application as if the adjustment is current because they were in error in, rejecting it outright. In this instance, in your instance, not filling out the form properly is one of the things that you've got to be really careful about. We had a 3-tier review just to make sure that we answered all the questions. So, especially when you're in, when you're dealing with a lot of applications, you have to do that. And I kept warning people, please make sure not only you review it, your attorney reviews it, but that you review it as well, because you have to, in final analysis, you're the one that takes control of your immigration process.
Okay. Let's go to another AA. I'm going for visa stamping in India. When they applied for H-1B approval, I have one layer between the client and my employer. It is mentioned in the H-1B application, also an H-1B approved. Now, middle layer removed between client and my employer. Is that I need have any amendment for this? Is that okay if I go for it?
No, but I would get if your employer can get a new end client letter saying that they're working directly with you, that's probably a good idea.
Okay. Another AA, if L1A visa extension is rejected while AOS is pending, does it have any impact on AOS GC process? Also,
no.
If there is an RFE and we don't respond to it, but rather switch to AOS EAD in the same company, is that okay?
You can, you're not going to have a safety net You always want to have a safety net. And there should be no reason why, if you've been on an L extensions, I don't understand when they get denied. Because you just have to show that and there hasn't been a lot of changes within the L regulations as they have been in the H-1B. So your previously approved L extension, as long as there were no, major changes in your job duties, should get approved.
Okay. Another question from the chat, Ananta Pilaka. I'm on EB2 India. PD is 12/15/2011. Current PD is 5/11/11. Application date, 7 months behind. What is the prospect of moving the dates ahead?
Yeah, I think there will be, I think before the end of this year, 2021, my prediction is that there'll be legislation to remove the backlogs. So I know, I'm almost certain of that. So that's why I tell people it's important to get your perms in, because if you don't have a approved perm application pending, then you won't be able to benefit from this change, and they may go back.
Okay. Another question from an AA. To understand this, the situation he's explaining, if you use EAD with current employer, you just explained saying you don't lose H-1B status. Then does that mean if we stay with current employer, we can continue on H-1 even if current H-1 is expired by using EAD?
Well, you're not then staying on your H-1, right? If it's expired, your status has to be valid for you to hold that status. So you would be using your EAD. So the only way your H-1 would, come here, the only way your H-1 would still be valid is if you file for an extension. You filed for an extension, you can continue working on your EAD, but you filed for an extension of your H-1B status.
All right. There is Sandeep Kaur. I don't know where she is, it's still in India or here. It is appropriate to mention about genuine health issues while following up on 221G on H-1B stamping. Is it appropriate? Then I heard the consulates are very straightforward, and anything emotional may sound like putting pressure, which they may not like. But I have genuine health issues now and need to get medical treatment from the United States.
No, that's absolutely a valid reason. I would make sure you articulate that clearly and back it up with maybe a letter from your doctor that explains it. The food in India is different. The environmental issues may impact you. So there may be a large number of things that could impact your health while you're there. And I think if you outline it, because the question is going to be, well, that's where you lived before. Why is it bothering you now, right? So think of it as an equation. A plus B needs to equal C. So if your C is, I need to come to the United States for health reasons, your evidence, which is your B, and your reasoning, which is your A, have to align with why you have to go to the US to get, why is that condition coming up now? And number two, why would the best treatment be in the United States?
Sounds good. So Suresh Shastri is asking, does the 180-day rule apply to derivative applicant before start working using EAD AP? Can the primary do multiple jobs once 180-day period complete after received date?
The I-140 needs to be approved, and the adjustment needs to be pending for 180 days before you change to same or similar employment with another employer. The H-4 is a dependent classification. Who they work for and how they work is not dependent on this process. So they're not subject to that at all.
All right. Akash Bhandari is back with another question. He wants to make sure, say this is a new question. I have applied my H4 and H4 EAD August 2020. I got a fingerprint request for February 5th. I completed that. Meanwhile, if I got a job and get an employer who's ready to file my H-1B, is that possible for me to apply a new H-1B while my H4 and H4 EAD is still in progress? There's no decision made.
You can, you'd probably submit a receipt notice of that, and sometimes they won't adjudicate they call these bridging applications. So they won't adjudicate it until the underlying extension or so forth is approved. If you're still in H4, that means you filed an extension, but your H4 has not expired and you want to get on H-1B and you're not subject to the cap. Then what you can do is go ahead and file an a change of status to H-1B from H4, withdraw your H4 extension, and change status that way.
How much time do you have to today?
1 o'clock.
1 o'clock. So I think I've got enough questions to go through 1 o'clock. So I would appreciate if viewers out there send an email to us to info@challalaw.com so that we will be able to respond to that, to your questions today. I have enough questions till 1 o'clock. So let's go to Venkat Challa. My daughter living here since 2015 on H4, going to college in fall 21 on H4. Her H4 visa expired in November 20th. My company applied for extension and we got the receipt, waiting for fingerprints. As the present visa is I-97 expired for my daughter, the instance residency is showing as out of state. Is there a way we can expedite fingerprints to get her in state residency?
No, they shouldn't do that because an extension, as long as she's under 21, an extension of her status shows that means that she's still in, she's in a status. Well, that's because she's in a status authorized. But she's allowed to stay in the US. So most universities will look at that. If you talk to them directly, there's no mechanism within the university. I've drafted the in-state regulations for the state of Virginia, so I'm incredibly familiar with the variations and the various issues. So a lot of times if you go to the DSO, the DSO can direct you to the team that reviews whether a person is in state status or not. And if you let them know that you filed a timely extension, they may sometimes correct that within their system.
All right. Ananta Pilaka is back, is the guy who had the EB2 PD, 12, 15, 11, and application of 511. He's asking, would it help if I downgrade to EB3 that enables me to only apply for 485?
Yeah, you can do a downgrade to EB3, filing a new petition. That means you retain your EB2. And if the EB2 numbers advance, then you can subsequently interfile and leverage your EB2.
All right. Another AA. Also my wage with current employer is L2 with 80K, but with my previous employer wage is L3 and salary is 125 plus. Does that be an issue going for H-1B stamping, lower salary than previous employer?
Not if everything was clearly outlined in because your job duties may change, your geographic area would change. Let's say you moved from New York City to working in Richmond, Virginia, the wage level will change. So if there are changes that are similar to that, then that shouldn't be a problem.
All right. Next one is if EB2 to EB3 downgrade as filed as an amendment, then do we lose EB2 I-140?
Yes.
EB3 I-140 approval?
Yes, so you shouldn't file an amendment, you should file a new EB3.
All right. Another AA, Lakshmi Garu, thanks a lot by heart for your continuous help. Is H4 premium processing available? If not, when will it be available? We are waiting for this to apply for H4 EAD.
Right, no, they said they wanted to do that to get more revenue, but the mechanisms have not been put in place to accept H4 EADs as of yet. Stay tuned. When it happens, we'll let you know.
All right. Vignesh Reddy is back. I understand that if there are no RFEs and everything goes well, I will be on H-1B by October 1st. My question is if there are any RFEs which will cause a delay, and can I still apply for post-completion OPT EAD before graduation somewhere in October, November, in December? Continue work on OPT while waiting for H-1B result?
Absolutely, because your change of status has not been approved. Once it's approved, though, you would no longer be in F1 status, but as long as your F1 is valid, you can apply for OPT.
We are getting thank yous from Ananta and Sandeep Kaur. Thank you.
Guys, again, if you're thanking me, like I said, it takes, Shaker takes out his time to moderate, Kara takes out her time to put all this together. I always enjoy trying to help the community. There is something we can do that's pretty amazing, which is influence the administration in their policies for H-1Bs and green cards. But in order for us to do that, I am going to need a sizable group that I can say, this is the group that I've been talking to. So please get, email out the Telegram link to your friends so we can get a bigger group. So we can, it's not just I will be making the impact. I may be your voice, but you can make the impact. So help me be impactful for you. And thank you again, Shaker. I want to thank you for your.
I got three more questions.
Oh.
I promised them that, that we will not take any new questions. So, can you shed some light on wage level requirement for current H-1B extension? Have they been reverted back, or are we in for a higher wage requirement for current H-1?
No, they were reverted back.
Okay. Another AA, how long can you be on AOS EAD without job offer once you move out to new employer?
If you're I-140 and I-485, has been pending for 180 days, you can even be self-employed in same or similar employment. So you want to do that after the I-140 is approved and the 180 days have been pending, but before the USCIS either issues an interview or issues a request confirming that you have employment. I don't know when that will take place.
Some thank yous coming from Maunik and Venkat Challa. And here is the last question for today, ladies and gentlemen. Appreciate your patience. If you could not ask today, please do send to info@challalaw.com and we'll definitely get a reply to you very soon and very fast. Last question, Mariangela Bassi. Good afternoon. Please, the H-1B visa as a result of sponsor from an employer can be issued only within March to start job on October 1st?
No, you can only apply in April, which is 6 months prior to the start date. But it will only be approved with an effective October 1st date. And the reason why you do that is there's so many people applying. If you waited, there's not going to be any H's left. If you're on an F1, if you're on OPT when you file, or a STEM OPT, and it expires in the interim, there's something called cap gap. So there are protections for that, but you need to file April 1st, not March. You have to register in March, but you file April 1st.
Yeah, if you want further information, Mariangela, just send an email to info@challalaw I'm not sure if you're familiar with the H-1B registration process. Since your question says a sponsor, result of sponsor from an employee. So we'll send you, the details of the registration process that clearly explains, when you have to register, when you will be selected in the lottery, and when you will be ready for work. So it's it's not a complicated process, but I think it's good to understand that. So send an email to info@challalaw.com. Thank you all. And I just want to say this weekend is a Valentine weekend. Don't forget your loved ones, whoever is your loved one on the other side, or in your side, left side, right side, think about them.
Well, I hope you don't forget your Valentine's on
I never forget.
Valentine's Day either.
I think about it in the sleep at the beginning of the year.
So that's good. Thank you all for participating this week. I look forward to talking to you next week. Like I said, we can really do something pretty spectacular as a group. So I hope you join me in trying to effectuate change for all of you and make things easier. So maybe one day we don't even have to have these webinars because things are so easy and there's so few questions. Have a great week.
Yeah.
Thank you again, Shaker. Thank you, Kara, for everything.
Just want to say thanks to Suresh and Mariangela. They're saying thank you very much for all your help. Suresh says you guys are rocking. Keep it up.
Thank you,
I
Suresh.
don't know how to rock and roll, but I'll do my best.
Thank you again.
Have a good week.
Bye-bye.
Take care.